have two cases on the docket today. We will take them in the order that they appear. Our first case today is Eva Flores versus Jane Flores. Counsel, if you are ready, you may proceed.
I'm ready, Tom. Thank you. Your Honor, we'd like to reserve 3 minutes for rebuttal.
Okay, so noted.
My name is John Glassman. I'm an attorney in Pensacola. I practice primarily in the areas of probate, guardianship, and estate planning. And I represent Eva and Mia Flores in this case as the court-appointed guardian ad litem and attorney ad litem for the two children. So the two children at the time I was appointed were 10 and 11 years old. This case is about whether the court erred in applying a strict interpretation of the doctrine lex locus contractus. So what we had here was a conflict of laws question. The facts are extremely compelling in this case, where you have a wife stabs the husband when he confronts her about cheating.
Counsel, if we could just stop right there. Is that record evidence in the trial court? Was that evidence admitted on that fact that you're bringing before this court today?
Yes, Your Honor, I believe that was an affidavit that co-counsel had filed with all that in there.
But no evidence in the trial court on that question? No evidence?
Well, I guess I should explain it like this, Judge. It's the report that I filed as guardian ad litem. Nobody objected to it. The court accepted it as is, along with the affidavit for the summary judgment hearing.
Okay, and I think that there was a motion to strike earlier in this case, that there are several assertions in the initial brief that are unsupported by any citation of the record. Is that correct?
There was, Your Honor, but this court denied that motion.
I understand that, and I think you've argued in your reply brief that that's res judicata. Is that right?
That's correct, Your Honor.
Do you know what the elements of res judicata are?
The elements of res judicata?
Yes.
Well, it's been argued before, and you can't come back and argue it again.
And it's a determination on the merits, is it not?
It is, Your Honor.
Right, and did this court determine on the merits on the face of that order?
No, Your Honor.
Okay, thank you. All right, so I think, counsel, I would just, really counsel to stick to the facts that are in the record and that were before the trial court.
Okay. So Matthew Flores was a resident in the state of Florida, and he took his two children and moved to Pensacola, Florida. When he moved to Pensacola, Florida, he purchased real estate in Pensacola, Florida. He enrolled his children in Pensacola, Florida. He, and that's been stipulated to by the appellee, Your Honor, that he was a resident of the state of Florida when he died. Prior to him moving to Florida, after he moved to Florida, he contacted his attorney in Los Angeles, his long-term attorney, Mr. Foster Tepper, and he redid his estate plan. Actually, he didn't redo it. He didn't have any estate plan documents.
But there were no documents when he was contacting his attorney about changing the beneficiary in his life insurance policy, right?
Correct,
So is there
Your Honor.
what relevance do these estate planning documents have to the life insurance policy that is in dispute here?
Well, what we're dealing with, Your Honor, are the life insurance policy proceeds going to be paid to the former wife, or are they going to be paid to the conservator in California on behalf of the children?
Right, so, and really it's a question of choice of law, right? Isn't that what this
The
case
question
was?
is a choice of law, Your Honor.
Right, and so you started, I think, on the right track, the lex loci contractus, right, which is typically going to be applied unless, and you've argued, unless there's a public policy exception.
Correct, Your Honor.
All right, what is the public policy exception here?
The public policy exception, Your Honor, is that the court can apply the law of the state of Florida if there's a Florida citizen in need of protection and a compelling reason why the Florida, or not even a compelling, but legitimate reason why the courts in the state of Florida should protect its citizens. And in this case, the specific issue is whether the court should assume jurisdiction to apply Florida law on an insurance contract purchased in California when the decedent moved to Florida.
I think we're straying a little from the question, what is the public policy at issue under the public policy exception that you're arguing should allow Florida law to apply here?
To protect Florida citizens, Your Honor.
That's
If-
the public policy.
That's the public policy, yes, Your Honor.
Okay.
So anytime you can argue that applying Florida law instead of the law of the contract benefits somebody who lives in Florida, then Florida is not to apply its normal rules with regard to choice of law?
No,
Just
that-
all we have to do is say, well, it benefits a Floridian, therefore we don't apply
think
choice
that
of law
the-
from another state.
Well, it's clear that the facts of each case are very compelling when the court is asked to apply the law of the state of Florida. So it's not just can Florida take over a case and apply its law. It's not that. Does Florida have a substantial interest in protecting its citizens, number one? And number two, from a result that would result in a miscarriage or harm to a Florida citizen. The big deal that I found in researching the cases is all of the cases cited, you can boil it down to the fact that is this person a Florida resident? And in the facts of this particular case as alleged in the pleadings, this was a summary judgment hearing that we had, so there were affidavits and things like that, but it basically boils down to is who's going to get the insurance proceeds. So Florida has an interest in protecting minor children, and that's what it's all about. They were Florida residents at the time the decedent was killed. So if the insurance proceeds go to the children, that was the decedent's intended result. If they go to the former spouse, then the concern, and the judge articulated it in his order, is that the children will not benefit by receiving the insurance proceeds. As a matter of fact, he even said in his own order, basically, I'm very disturbed at the result in this case. Nobody anticipated that this was going to happen. And so I believe his exact words, and this is my colleague Mr. Pugh over here, to Mr. Pugh, this is not a good result. Nobody has suggested that this is a good result, and it needs to go up on appeal so the court can look at it. In doing that, Your Honor, he actually was focused on a footnote in the Roach case. And in the Roach case, it was, again, which law should we apply, New Hampshire law or Florida law? And the insurer had issued a policy in New Hampshire. These were snowbirds that would come down here for several months during the year, but they never arose to the point that they were actually Florida citizens. So the Florida Supreme Court in 2006 said that does not arise to the point that these courts should get involved. We are going to help the citizens of the state of Florida, but we're not going to go as far as to allow snowbirds to argue that the choice of law should be Florida for a more favorable result. And then if you go on to the other cases, in Sturiano, again, they were snowbirds and they were not residents of the state of Florida. The court in Sturiano, which I think is an interesting case, says lex locus contractus does govern. They were snowbirds. The holding, however, is limited to automobile insurance policies. So if you're in one state, you buy an automobile insurance policy, and then you move to Florida, you can't say, I want Florida's to apply unless you become a permanent resident of the state of Florida.
Right, and I think going back to Roach, certainly that case is not fulfilling the first prong, that there's no Florida citizen in need of protection. But again, I just don't think you're answering the question that we're asking, which is, what is the paramount Florida public policy at issue? We have a statute in Florida that says that, a life insurance beneficiary designation, terminates at divorce, but it also clearly provides an exception when the governing instrument, here the insurance policy, is governed by the laws of another state. So we don't have a paramount policy in Florida that every death of a person is going to terminate a beneficiary designation. And you're right, we look at the facts. And here in this case, less than 60 days before the decedent passed away, he had a marital settlement agreement that he entered into. a final judgment entered on that reflecting California law that if he wanted to change his beneficiary, he needed to take affirmative action. And under his policy, it was quite easy to do so. He just did not.
That's correct, Your Honor.
So I suppose, I guess that's the question is, what is the paramount public policy in light of our statute, in light of California law, and in light of the facts of this case?
Well, we always have to start with lex locus contractus in all the cases. The law of the land applies. There's no question about that. It's only when applying the law of the land creates a substantial burden on behalf of a Florida resident that the courts can say, we're not going to enforce the laws, in this case, in the state of California, we're going to enforce them in the state of Florida under our laws. So it requires a Florida citizen in need of protection. So like in the Claflin case, Your Honor, Florida took over that case when there was a question as to whether or not it should be Philippine law or Florida law, because Florida approves the sanctity of marriage. And it says comity requires parties be given motive and opportunity to be heard. The foreign court had jurisdiction, and the judgment does not offend public policy of the state. Now that's a 2020 case. What I think is interesting about that particular case, Your Honor, it's a family law case. And so what the court talked about is, in family law, they've actually codified this exception to lex locus contractus, and comedies rule that we don't have to acknowledge the law of a different state. And section 61.0401, which essentially boils down to if that law is going to be unfair or the law is going to be unfair, or the law is going to be illegal, then the policy of the state is to enforce the clause according to the specific facts of the case.
But I think that gets to Judge Rowe's point, which she made a minute ago, that the statute 732.703 has the explicit carve-out that when the governing document's governed by the laws of another state, then this doesn't apply. And that, so the legislature is expressly saying we're not going to negate every instrument, just because of public policy. So how do you deal with that carve-out, that language in the statute?
Well, again, I think you have to look at the specific facts of every case. We start out with lex locus contractus, apply the facts of the law to that case. Again, in Claflin, it was Philippine law versus Florida law. And because of the egregious facts in that case about trying to go back and get a marriage annulled after they'd been living for 19 years together, the court said that that is a legitimate interest that the Florida court should get involved in. The forum selection clause is to be reasonable, and if it's not reasonable for a Florida citizen, the courts can apply our own law. And in fact, that's what we asked it to do, is apply Florida's law, which says that if you get divorced, it's assumed your spouse predeceases you, so they don't take. Again, in this case, we're looking out for the children, and we did have a Florida resident, owned real estate, children were in school, all of that, but the former wife is getting all the insurance proceeds. And again, because the facts of this case are so compelling, the trial judge was very disturbed at his ruling. And he said, I don't think I have any choice but to rule like this. But in fact, if you read the cases, he had plenty of opportunity to rule like this. If you look at the Acme case, Acme Circus versus Cooperstock, it says, there's no law to the contrary in the place where personal property is situated. It's deemed to follow the person of its owner and governed by the law of his domicile. In the Kellogg Citizens versus Felton case, it says, while the statutes of one state have no force or effect in another state, The justice in one state will be, by the rule of comity, assume jurisdiction of causes of action which are transitory in nature and arise from a foreign state. And they say essentially that in all of these cases, you gotta look to the law of both forums, and if the law in both forums differs substantially and it's a Florida citizen, Florida can assume jurisdiction under their own laws to make things right. And that's all we're arguing, is that the court, if you read the court's order and then you read the motion for rehearing, the court did not do any balancing test. It didn't do any evaluation as to if it happens under California law, this is going to happen. If it's under Florida law, that's going to happen. He didn't do it. The other thing about when he made his ruling, the cases, almost all the cases state that one of the things that he has to do is consider the restatement of conflict of laws, which that was not considered at all by the trial court. It was noted in the memorandums that the restatement has got to be acknowledged.
So it was argued to the trial judge, correct?
The restatement,
Mm-hmm.
it was argued within the context of everything else, Your Honor.
Right.
It was in the pleadings.
So it was before the court. Did he need to make a written finding that he'd considered it and applied it? Is that necessary for us to be able to uphold his ruling?
Well, I suppose you could answer yes or no to that. If he didn't put it in his findings, we as the attorney should have told him it's not in your findings. But there was really no way at that point in time that we could anticipate that the case was going to turn the way it did. If I could suggest to the court that in Quintana, which I think is a very compelling case, this is a case where husband and wife were Cuban nationals. And the husband acquired a promissory note when he was in Cuba. Actually, he acquired stock when he was in Cuba. He moves to Florida. He gets a promissory note for $810,000 and says under Cuba law, I don't have to apply that. I mean, under Cuban law, it's mine. And the court said, no, those are movables. So if it's real estate, it's pretty clear you have to apply the law of the land where the real estate is located. But if it's movables, anything you can take with you, in this case, a promissory note, it's governed by the law of the state where the movables are located. Arguably, the insurance policy was in Florida. It was taken out in California. There is no forum selection clause in the insurance proceeds, but there is an important distinction.
And before you go on, you are in your rebuttal time.
Okay. Then with that, Connor, I will sit down. Thank you very much.
Thank you, counsel.
Good afternoon, Your Honors. Philip Pugh on behalf of Jane Flores. May it please the court. I'm going to begin with what I think is my strongest argument, and the fact is the panel's already come out with questions on that issue, which is the statute itself. So 732-703, as you indicated, contains a specific carve-out for situations in which other states' laws apply. I think the answer to Judge Rowe's question is what is the paramount public policy? Well, I think what you're being asked to decide here is whether or not Florida's automatic revocation of a life insurance beneficiary upon divorce is the type of thing that we have such a paramount public interest in, or public policy in, that we would actually require the courts to enforce this provision even when another state's law would otherwise apply. In other words, is it so strong that we would refuse comity to a sister state that rules on this issue? And I think the legislature's already made that determination in this instance by putting subsection 4G in the statute. In fact, the statute has 10 enumerated exceptions. The sailboat key case that was cited in the briefing tells us that when a rule, in that case it was usury, they say when a rule has a series of exceptions, it's pretty hard to say that that's a paramount public policy. Here we have 10.
Okay, but the exception is going to be governed by the principle that you interpret the contract as the law where it was executed.
Lex loci, yes.
And that, correct.
If I
And
said it right, I hope I
there is an exception to it. So it's kind of circular to say that the existence of the exception completely forecloses the use of the exception to that exception, doesn't
I
it?
do think it's a bit circular. I spent some time thinking about this, and my conclusion was that, let's say this court determines, yes, we have a paramount public policy in revoking these designations, and so we're going to refuse comedy, we're not going to acknowledge other states' law. Well, then I think we just stripped 4G out of the statute. I don't know when else it would ever apply. I think it becomes meaningless if we do that.
I think I think one of the points he brings out from the trial court's order, you can definitely see the trial court was struggling with this ruling, and there is some record evidence on, kind of maybe a basic unfairness for the former wife to receive the proceeds of the life insurance policy as opposed to the children who lived with the decedent right before his death and had moved to Florida with him. So I think that the argument the appellant made was that these children should be provided for, and that is a public policy basis to set aside the general rule of lex loci contractus. Could you address that?
I can, Judge. There's one interesting thing that I've gleaned from the record in the lower court, which is that it's not entirely clear that children were living here when he died. My client's affidavit states that they were living with her in California from May of 2020 to the present day. He died in August. So I'm not entirely sure the situation there. What I do know is that my client has custody of the children. They live in California now. And so, just taking a look at the facts of the case and what Florida's connection is, this is was a California couple. They married in California in 2009. They divorced in California in 2019. They were raising their kids in California. They completed their divorce in California. The only connection to Florida at this point is that he moved here shortly before his death. In fact, even the PR of the estate is a California resident. So these monies are going to California, whether they go to her or they go to some conservatorship, through the estate to a conservatorship to someone to keep them there. They're going to California, and so I think Florida's connection is tenuous at best, other than, again, just the fact that he came here, was here about 9 months or so, and unfortunately was killed. Actually,
Would this case have been different if there had been record evidence submitted in the trial court that the decedent had gone to his insurance company and made an effort to change the beneficiary, but it just hadn't been performed? Would that be a different kind of case to be looking at?
I don't think you come to a different conclusion. You could get there. In California, the rule is that the beneficiary has to be changed in accordance with what the life insurance company requires. There's 3 exceptions to that, and one of them is that the individual did everything that they could to get it done, and then for whatever reason they couldn't and they died. But if you read through the case, and forgive me, it escapes me, but it's in the briefing, the court goes through it and it actually looks at several cases where even situations where somebody signed the paperwork, they found the signed beneficiary form in his files, and they said, well, this isn't good enough. It's not in an envelope addressed to the life insurance company. It's not stamped. He didn't give it to somebody on his deathbed. There's not even a suggestion here that he returned anything. What we actually got, we were a little surprised when we got the affidavit in opposition to our summary judgment from the PR that said that the decedent told his insurance company he wanted to change it, and they started drafting forms. At that point, we were already queued up for summary judgment. What I told the trial court was a couple things. That this affidavit, it appears to be hearsay. There's no foundation in it whatsoever for how she purportedly has this knowledge. And I can certainly tell you that we subpoenaed the life insurance company, and we got nothing that would suggest that they had any idea any of this was going on. There was no paperwork they were waiting on or anything like that, at least as far as what they sent us. And so we proceeded, and I don't think the trial court found it to be a relevant fact. It certainly wasn't one of the ones that were enumerated as what he relied on.
Right, and again, just to reiterate, the decedent had an MSA and a final judgment giving him clear notice that he needed to make a choice. And as I read the insurance policy, all he had to do was sign it and put it in writing, and there's no record evidence that that happened.
Yes, ma'am, that's right. And that actually takes me to another point. When we look at, this is a case of first impression as far as I can tell as it relates to life insurance. The law is pretty well developed in relation to automobile insurance. My first thought is that's probably because there's an exception in the statute, so this doesn't really come up. That's my guess, a speculation. But on the auto insurance cases, there's 3 requirements. First thing we gotta do is find a Florida citizen in need of protection. And in my briefing to the court, I leaned on that in need of protection a little bit. By all accounts, this was a successful businessman. We've not done any discovery, but I do not dispute the allegations on that issue for these purposes. That is to say, they say he was a successful businessman. He created and ran businesses in California, Florida, Texas. He was down in Turks and Caicos trying to start a business down there apparently when he was killed. When you look at that MSA, the settlement agreement that was signed in January of 20, it says on its face, as you noted, it says on its face that it will not revoke the policy. And if you go down and you find the decedent's signature, you'll find that it's right on top of his California attorney's signature. And then subsequently, he finishes the divorce in California, and the court says the same thing. The court only says it on its judgment, and the court also incorporates the settlement agreement that says that as well. But I say all that to get to this point. I don't know that a successful businessman operating with the benefit of counsel at all times could be described as somebody who needs the protection of this court. As you indicated, all he had to do was change the policy, change the beneficiary, and he just didn't do it. He may have intended to. We don't know that. We're not going to know that. But what we know is he didn't, and I think that's the long and short of it. If we take a look at the timeline a little bit, I think it's important. Remember, he claims to have moved here in October of 19. So, there's been some argument in the lower court about whether he ought to be afforded the protections of Florida law immediately upon moving here. Well, I would point out that it's not as if he tried to move the divorce proceedings here, or complete anything here. He continued what he was doing in California. In January, so 3 months after he moved here, while he's a Florida resident, that's when he signed that settlement agreement with the benefit of counsel, acknowledging what was happening in California.
Counsel, I don't want to speak for your fellow counsel, but my understanding is that the party that was in need of protection was the children and not the now deceased father. Am I misunderstanding that?
I've heard it both ways, and to begin with, I certainly don't think the owner of the policy needed protection for sure. In return, or in relation to the kids, they're children, right? Obviously we know that they need protection when they can get it. All I know to tell you here is that those children are and have been with their mother in California since May of 2020, almost 5 years ago. So I don't know that, there was a reference to this doctrine of parens, and I'm going to say this wrong, parens patriae, I believe. It was referenced in the briefing from the appellant. I didn't see a case that would apply it here, but it's thrown out there, and I just don't know how this court, or this state rather, operates in that capacity for a child in the custody of someone in California. So that's really my only response to that, Judge. This case, as counsel suggested, and as Judge Rowe noted, we did file a motion to strike because there were so many salacious allegations in the briefing that I contend are not supportive of record evidence. A lot of them are contained in the guardian ad litem report. There was a suggestion that we didn't object to it. It's strange to say that. It was filed in the lower court. There's case law in Florida that says that does not make it evidence. If it had been raised on summary judgment, then I would have objected to it because it's double and a lot of it is triple hearsay. I don't think any of it is based on personal knowledge. And so I don't know that those things are before the court. But that being said, this is clearly a case with bad facts. I've argued the law the whole time. But remember, bad facts make bad law. And I think that what we want to do here is not let these bad facts create bad law. That then everybody's gonna have to live by from now on. I mean, the statute does what it says, you know, and it creates the exception for a reason, I assume. I don't think that we get to strip that exception out of the statute. Going on, there are a few cases that you were cited to in which the court did implement a public policy exception and override the foreign state's law. One of them is the Gillen case, and that's an automobile insurance case. There's something that I noticed, and I didn't notice it when we were doing the briefing. I picked up on it in preparing for today, which is that there's a fundamental difference between all these automobile insurance cases and the life insurance case that you have here. And that's because in the automobile cases, the dispute is almost always, well, it is always, between the insured who wants to be paid based on the better benefits that are mandated by the state of Florida, and the insurance company who doesn't want to pay. They want to, you know, have the law of their chosen state. And it brings up some freedom of contract issues. You know, if you've purchased a contract out of state, say New Hampshire, for example, and it provides for New Hampshire's type of benefits, and they're charging New Hampshire rates, and then a Florida court makes the insurance company pay based on our rates, that, you know, it implicates a freedom of contract question, and that's why notice becomes such a big deal. You know, the insurance company, when they're given notice, can then decide, do I want to issue this policy? Do I want to charge Florida rates? You know, do I want to pull out or what? With life insurance, I don't think that ever really comes into play. You know, in this case, there's no suggestion that the life insurance company did anything wrong. You know, the Gillen court tells us that the public policy there is to protect Florida insureds from inequitable insurance contracts. And you've got a clearly articulated policy there. It makes sense, but there's no suggestion that anything inequitable happened here. Another case that you were cited to where it was successfully done, that the exception was successfully implemented, was the Coughlin case that you heard about a few minutes ago. I would suggest to you, I don't think the Coughlin case is analogous because it travels under a statute within the family law statutes that specifically says when we're going to ignore another state's judgment. And it explains how, which again is completely the opposite of what we have here, where our statute on life insurance does not say that. But it is interesting that even in the divorce context, this Florida statute 610401 gives specific authority for disregarding the judgment of a foreign country if it would contravene the strong public policy of the state. And then it goes on to define strong public policy as one of sufficient importance to outweigh the policy of freedom of contract. I would suggest that just using the natural definitions of those words, to me, paramount sounds like it would require even more than that, even more than strong. The last one I wanted to refer you to is Enri Estate of Santos. And I think this really is probably the most instructive case I was able to find. This is the scenario where a couple was married in Puerto Rico, and there was a prenuptial agreement in Puerto Rico. When the husband died, the wife got into a dispute with his children from a former relationship. And the question was, is the prenup governed by Puerto Rican law or Florida law? And the court said that lex loci applies. This was done in Puerto Rico. And so, you know, even though it's not how we do it, it's not what we would do in this situation, that's what applies, except for the Florida homestead. And that makes sense to me because the Florida homestead protection is enshrined in our Constitution. There are no exceptions. And so I think that's a paramount public policy, and that's what the court said. I don't think we can take that and extend it so far as you see here for a statute that has the exception built into it. I'm closing in on all that I have. I just want to close with this. The parties were married in California. They lived in California. They bought the policy in California. They got divorced in California by a California court represented by California counsel. The California judgment says this does not revoke the policy. I don't think that we can, here in Florida, tell that California judge that your order does something that you explicitly said it doesn't do, unless we have a clear paramount public policy that allows us to refuse comity in that way, and I don't think we can do it in light of the subsection 4G of the statute. If there are no questions for me, I will.
Okay, thank you,
I'll have a
counsel.
seat. Thank you, Judge.
Benjamin Alexander, I represent Ms. Delgado, the representative of the estate of Mr. Flores. To address a few things, so the trial court ultimately determined that the California law would apply. However, the analysis of the trial court ended there, and it should not have. California law requires a governmental interest test, and that test has been used in California for nearly 50 years now. It was determined in 1978. It's specifically for use for interpretation of choice of law issues in insurance contracts. That governmental interest test combines the restatement second of conflict of laws along with analysis of the interests of the respective states to determine which state's interests would be more impaired if that state's interests were not applied. The three-part inquiry determines whether there's a difference in the state laws. Then it goes to determine whether there's a respective interest of each state in the application of its own law. Then finally, if it determines there is a valid dispute, then at that point it would weigh the respective interests of those two states. Here the trial court determined conclusively that Ms. Flores was entitled to the insurance proceeds under California law. However, we believe that if the court is going to determine that California law applies, the trial court should apply California law, and that would require another step. Now, that would require the court to perform the governmental interest tests. Perhaps the same result would end up. But without having done that, we believe that the job of the trial court is simply incomplete. And for that reason, the trial court should make a determination of those respective factors to determine which state's interest would be more impaired by the non-application of its own state laws. I have 7 seconds left. I don't really have much time to go into a new argument. I appreciate your time today.
Okay, thank you, counsel. Thank you all. We will hear the next case, give you a few minutes to change positions.